The Independent National Electoral Commission, INEC, has made it clear in the past on the conduct of party primaries to select candidates for different legislative positions. One clause that INEC has been clear about is that every party primary must be monitored by that electoral body. But litigations are littered in courts around the country, with some people challenging INEC's stance on primaries conducted without the presence of their representative. And also, the list of some candidates submitted by political parties has been questioned. Joining us on the show this morning, as we discuss the huge number of litigation over the outcome of party primaries around the country, and also the situation in the People's Democratic Party, PDP, in Delta State, is Liborous Oshoma, a lawyer and public affairs analyst. Good morning. Welcome to the show.
Yeah, good morning. Thank you.
Good morning, Liborous.
Yeah, good morning, Doctor.
Good to have you on the program. Well, we just, had a conversation with two persons representing two factions of the PDP in Delta State, and the issue was the gubernatorial candidate. Is it Oberewori or David Edevie, with regard to the ruling of the Court of Justice Taiwo, Federal High Court? And we had, one of the parties concerned saying, well, there is no cause for alarm. Oberewori remains the candidate. The matter has gone on appeal. The other person, Mr. Iwure, who was here with us in the studio, saying, no, it is David Edevie, because Oberewori has no valid certificate that could be called his own. He falsified his age, he claims. He has falsified certificates, he says, and that the ruling of the court is the right one. Okay, why is it a big issue? About date of birth, about certificates, about identity in Nigerian politics?
Yeah, I would want to start by quoting the Supreme Court. Supreme Court in Degi's case stated that the issue of certificates forgery is a big problem in Nigeria, and that it is high time the court sits down to deal with all of those issues. And it is in that light that the drafters and framers of the Constitution introduced Section 661I to say that it is part also of INEC, it's stated in INEC form, if you have presented a forged certificate to INEC before, whether in that present election or previously, it's an issue. And then also, the issue, there are two issues here from what I have gathered and listened to. One is forged certificate, the other one is on identity of the certificate owner. And for the issue of forged certificates, the case of Obaseki would apply. If you claim that the certificate is forged, then you write to the issuing authority. But if you're claiming that this certificate is authentic, but the holder is not the actual owner of that certificate, then you don't need to write to the issuing authority. What you need is for the owner to actually establish that the name on the certificate belongs to him via a deed of poll as held by the same Supreme Court. But in this case, I have also read the judgment of Justice Taiwo, and that your guest in the studio referred to. And Justice Taiwo heard loudly that the discrepancies in the deed of poll attempting to cure the date of birth and the names also as something he cannot, that these discrepancies, he find it difficult reconciling them. So in that circumstance, what happens is that the date of birth and name are something that is unique to individual. You can't in one breath be born in 1979, in another breath be born in 1963, you finish primary school in 1977, and then on the face of a document, national document, issued by the West African Examination Council, your date of birth is stated there in 1979. And then you finished primary school in 1977 from your primary school leaving certificate. And then sometimes later, you now go to say, oh no, I want to cure these defects. It is only WAEC that can cure that defect. No court of law, no affidavit can cure that defect. And the Supreme Court had heard in Prectorial Authority. I think we shouldn't be conflating the issues. There's the issue of forging certificate and another, the issue of the certificate not belonging to you. They are two different things. If I parade a certificate that is not mine, you are gradually working your way to prison. It is incurably defective for you to now say, no, it is the discrepancies in the name and date of birth. When you are not, for you to even alter that document with an affidavit, it also amounts to forgery. So it's a criminal offense. And the court has heard that you need not be tried. You need not be tried for a criminal offense before you can be disqualified by INEC. So all of this issue of no, I have cured the defect, my date of birth, I've cured it with a deed of pool and then a gazette signed by you because you are the speaker. You are an interested party in the matter. Sometimes I wonder how our politicians reason and behave, or what they take the rest of us for. You are an interested party in the matter. You have issued an affidavit correcting your date of birth, let's assume. And then you are issuing a receipt and a gazette signed by you as an interested party in the matter. You know, so I think the tidier thing to have been done would have been to take this document before the appropriate person to look through the document before issuing you a receipt and gazetting appropriately. But for you to now say that you are, because you are a speaker, and then you sit down in the comfort of your bedroom and issue any statement and say it should be a valid statement, it will also raise big questions. That is why there are this inconsistency. And Justice Taiwo had rightly ruled, you can't have a date of 1979 in a document, signed in 2011, and then issued a receipt issued in 2022. You know, so all of this discrepancy. So you made that document in 1979. Let's assume that you were born in 1979 because that's your certificate still carries your date of birth. So without the affidavit, anywhere that certificates get to, in the record of WAEC, you are born in 1979. WAEC had not corrected that. So what you're doing now, you're carrying an affidavit everywhere. But if you get to WAEC, from the document WAEC has issued, Oboroweri is born in 1979. Oboroweri is saying, no, I was born in 1963. So I think the best thing to have been done is to ensure that you get to go back to WAEC and say, I think there's a mistake here. I had my certificate from Ekpoma and it was correct. I had to go back to the school to correct and issue another certificate for me.
Right, Liborous. Speaking of more discrepancies or alleged discrepancies, Section 84 of the Electoral Act says that INEC must monitor primaries, and Section 29 says only candidates from valid primaries names will be submitted to INEC. However, there are reports making the rounds that INEC is rejecting reports by its own officials who monitored primaries, and that INEC is accepting names from political parties of people that did not participate in validly monitored primaries. What do you make of this?
Quickly, if you permit me, INEC for me is acting as an interested party in some of these matters. INEC is acting like the INEC of Maurice Iwu. And Professor Mahmood is somebody I have at various fora, eulogized for the innovation he's brought to INEC. But I think it is high time he begins to call some of his staffs, mostly those ones at the headquarters, to order. And before I proceed to this, let me quickly read. If you look at on this Delta issue, the document issued by INEC on the Delta issues, this is to draw your attention to judgment order of the Federal High Court in Abuja, that's to PDP, in the above-mentioned suit, which has been served on the commission. While hoping your party takes note of the judgment, please accept assurance of the commission's warm regard. Signed, Secretary Anthony. In the case of Edo, same secretary, same scenario. The commission hereby draws the attention of the People's Democratic Party to the order of court arising from 3 suits. In line with the order, the commission is restrained from accepting and recognizing any list other than the list contained in the names of the plaintiff as the PDP duly candidate for the election as heard by the courts. In one breath, you say, we recognize the court judgment. Please, we will not recognize this other list because the court had said this is the authentic PDP. In another breath, you say, oh, I'm bringing to your notice a court judgment, and it ends there. And that is why, also in the same vein, INEC would send officials, would pay money, send them to the field. That's why they have resident electoral commissioners. That's why they have state offices. They will send officials to go monitor election because by virtue of the same section 29, the political parties are supposed to give notice to INEC. And the essence of giving notice to INEC is to ensure that this INEC also makes preparation to monitor that election. And after sending officials to monitor the election, not even the resident electoral commissioner can invalidate the report of the official that monitored that election. But for somebody to sit down in Abuja and now, like in the case of Kano, Abia, Akwa Ibom, and Borno, now begin to substitute names, that is not the business of INEC. It is not for INEC to sit down and begin to substitute names of election they did not monitor in place of the one that they monitored. It shows clearly that INEC, you know, there is something fishy about INEC. Also, on this case of Delta State, INEC has said there is an appeal. For a declaratory judgment, you said there is an appeal. In Edo, despite the appeal, you accepted the judgment because that is the position of the law as at that time. But in the case of Akwa Ibom, in the case of Delta, you said there is an appeal. Is it in your place when there is no court order stopping you from going ahead with the order validly issued? Paragraph 7 of that order by Justice Taiwo commanded INEC and the PDP. And in violation of both paragraph 7 and 4, PDP has gone ahead to say, yes, they still retain Oborowere as their candidate. INEC now is asking the same PDP to furnish or do the needful. So what it means is either INEC is acting for somebody or INEC has been compromised in as far as this substitution. And I'm saying it with all sense of modesty that Professor Mahmood, the only things that he can be remembered are the latter things that he has done. Not even for the 2019 election, when some people still have issues. What he can be remembered now is how INEC dealt with the issues of political party primaries and the general election in 2023. Otherwise, his name, no matter the good works, his name might go down the same, with ignominy the same way Morrissey, whose name is no longer mentioned in INEC at all.
Well, shortly after the primaries, Mr. Mohammed Haruna, the National Commissioner of INEC, said that INEC does not have the powers to reject candidates whose names have been sent to it by the political parties. Is that the position of the law? Could that be the reason why INEC has, ignored, in most cases, state reports with regard to the primaries?
If you remember, Section 84, the entire Section 84 of the Electoral Act was an issue. The political parties debated it, candidates debated it, delegates debated it. What was the issue? Section 84.12 and Section 84.3. Before now, INEC didn't have the powers. I think the INEC officials should go back and read that law because Section 84.13 actually gives INEC powers to refuse or reject names submitted by parties for failure to comply with the provisions of Section 84. And so, Section 115 also forbids, of the Electoral Act, forbids multiple nomination. And this Section 84 gives INEC the power to reject nomination on the basis that, unlike before, where the court ruled that INEC's duty was just to monitor, and outside that, cannot do anything. So, on what basis did INEC reject the nomination of the then ruling party in Zamfara in 2019. If they do not have powers to reject nomination, INEC have powers to issue guidelines, and if these guidelines are not followed, INEC now squarely has the power by virtue of Section 84 to say, no, our guidelines were not followed, the rules we laid down were not followed, and we cannot, in all honesty, accept any other, any conduct arising from these primaries, most especially when INEC has sent officials to the field, or wrong informations were given to INEC. You say you're going to conduct the primaries in Erumugwagware Primary School, and then you go to Warri Township Stadium to conduct the primaries. INEC did not monitor that, whatever primaries you conducted in Warri Township Stadium. At the end of the day, once INEC issues a report that when they got to the field, there was nobody there, INEC has a right to reject. I think the professor should be properly schooled in the rules guiding.
Right. Does this actually impact, in your opinion, at this point, the general confidence that the public has in INEC looking towards 2023 elections, the general elections?
That's the same opinion I already have about INEC. As much as we have all praised INEC and what they had done consistently with the innovations and the innovations as far as the election is concerned. When you already have candidates who are being substituted, take the case of Umahi, take the case of Machina in Borno, a man who stood for election. You are substituting him for somebody who did not stand for that same election. And you know, how do you not want people who want to participate in election to have confidence in you? And that's why I think that INEC should leave all of these party politics. Just allow the party politicians do their thing. You have rules and regulations. You also have the Electoral Act. Play by the books. And once you play by the books, everybody will see INEC truly as an umpire and not as an interested party. And then please, quickly, please permit me to also go back to this issue of the Delta State. Do you know why? Because I grew up in Warri. So I have serious interest in whatever happens in Old Bende, Edo, and Delta. That's why I kept consistently citing the case of Edo, what happened in Obaseki's case. Because I listened to the lawyer in Abuja, and
Victor Ebonka.
Yes, Victor Ebonka, and he spoke as if those arguments should be reserved for the Court of Appeal and not for the studio. The issue is the discrepancies in the facts presented before the court. And on the face of that, the court has ruled. And then also, by virtue of Section 285, pre-election matters, you have 14 days within which all of these issues are pre-election matters. They are not, you don't have to wait until the name is submitted before you go to court. So, and then, lastly, I reiterate, the issue here is an issue of a valid certificate that is claimed by somebody who is not the owner of that certificate. It is not, the onus is not on the man who is saying the certificate is not yours because of the discrepancies in the document. The onus is not also on the court to say call witnesses. It's a documentary thing. There are documents. On the face of those documents, there are discrepancies. There are name discrepancies. There are date of birth discrepancies, which are date of birth and name are personal. So if you have incurable conflicting averment in a document, the court will not wait to call witnesses to begin to point out those averments. It is for the court to look at the document on the face of it and decide if truly, indeed, the man who is claiming this date of birth is actually the owner of the certificate. And that is what Justice Taiwo had done.
Well, very similar to the situation we had in Bayelsa State.
Exactly. In
the last gubernatorial election. We'd like to thank you very much, Liborous Oshoma, for joining us.
Always my pleasure.
Thank you.